In today's video, I want to take a look at 4 nuggets of employment law knowledge or information that I picked up yesterday when I was attending my annual employment law CPD, Continuous Professional Development. Okay, the first thing that I learned yesterday at a very good talk given by Marguerite Bulger, who's a senior counsel and who specialises in employment law. She advised us that one of the first things you need to look at as a solicitor when a client comes in is to see whether it's a claim or a situation that should go to the WRC, the Workplace Relations Commission, or whether it should go to court for an injunction. The general position would be that you go to the WRC in respect of any employment law complaint. However, there are circumstances where seeking an injunction in the High Court may be the most appropriate or perhaps the only course of action open to the employee. It should be used in rare enough circumstances. There is a costs element, cost factor to consider, but that is one of the first major decisions to be taken by a solicitor practicing in the area of employment law, whether the WRC or a court injunction would be the most appropriate avenue to take. The second nugget that I gleaned from the talk was the question of costs in the High Court. Apparently, lawyers, solicitors are unlikely to have their costs awarded in judicial review proceedings. So that's something that needs to be considered very, very carefully by both solicitor, barrister and client. The judicial review proceedings, the decisions in the High Court appear to be not granting the applicants legal costs. However, the good news is that statutory appeals, which is appealing a case from, say, the Labour Court on a point of law to the High Court, will see costs awarded to the applicant, to the employee or indeed the employer who is appealing the decision of the Labour Court if it is a statutory appeal. The third nugget of information that I gleaned was to do with reinstatement or re-engagement in an unfair dismissal situation. Obviously, the remedies for unfair dismissal are financial loss, which can be limiting enough, particularly if the employee has got a new job quickly enough, reinstatement or re-engagement. The significant difference between reinstatement and re-engagement, however, is that reinstatement will be from the day of dismissal. And this means that the potential financial accumulation, as it were, for the employee in lost wages and the costs, therefore, for the employer will be very significant. So somebody could be dismissed at, say, the 1st of June, and it may be 12 months or later before the case is finally dealt with or heard or finalised, in which case, if reinstatement, which is not that common but has happened and happens regularly enough, if reinstatement is ordered, then it's from the date of dismissal, and that has serious implications for the employer in terms of calculating the financial loss that has accrued to the employee. Re-engagement then tends to be from a specified date, not necessarily from the date of dismissal. So it could be from the date of the hearing, or it could be from the date of certainly the decision of the WRC. It couldn't be from the date of the hearing, I suppose, because a decision has to emanate subsequent to the hearing. The fourth nugget of employment law wisdom that I picked up at Employment Law CPD yesterday, organised by Central Law Training, was to do with the McKelvey versus Aaron case. This case I have written about fairly extensively on my website, employmentrightsireland.com, because there was a High Court proceedings. There was a Court of Appeal decision, and then it went to the Supreme Court. Now, I've written about both the High Court and the Court of Appeal, and indeed the Supreme Court decisions. Essentially, the headline news from the Court of Appeal and from the Supreme Court is that the employee who was accused of misappropriating funds or diesel or misuse of a diesel card in the workplace is not entitled to legal representation in a disciplinary proceeding, a disciplinary hearing or investigation. That is the general position. There are exceptions, but Mr. McKelvey was looking for the representation for him to be by a solicitor or a barrister, and the company said no, and the High Court or the Supreme Court and the Court of Appeal both said no, he's not entitled to legal representation. However, something that did come out of the holding of the Court of Appeal was the right to test the evidence. Now, I don't think, according to Marguerite Bulger, that the Court of Appeal specified what that actually meant, but generally the right to test evidence would involve the cross-examination of witnesses. So if the Court of Appeal says that the right to cross-examine witnesses is there for an employee, and if the Supreme Court didn't mention it or didn't overturn that or set it aside or make any comment on it, then it's probably fair to assume that the McKelvey Court of Appeal decision is authority for the proposition that the employee, even though he may not have the entitlement to legal representation, does have the entitlement to cross-examine witnesses and test the evidence against him. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thanks for watching.